And what we were hoping to do is really have this be very intimate, informal. Please ask questions. If we use a term, I'm sure if we use any abbreviations, you guys probably know them. You know how abbreviation intense workers' comp is. But if we use any terms you're not familiar with, please ask the question. If you have a scenario or some case thing that you're working on now, please ask the question. That's what we're here for. You get your hour and a half of free legal advice. We're going to do an overview of the three main laws, and then the interplay where we see most of the problems is employers want to fire people when they've been off for any significant period of time. They look at their leave policy and say they've exhausted it, we want to can them. And there's a process you need to go through, some questions you need to ask. And whether it's us or someone else, they really need to work with an employment counsel before they do that. Because this is an area that the EEOC is really funding, and they are really going after employers who automatically terminate people after the exhaustion of a leave policy, unless they do what we will call the interactive process. So with that, I turn it over to Rich.
All right, thanks. I had to put the pictures up so you guys didn't get us confused. It happens often. I call this walking Cerberus. This is Cerberus. Cerberus was the three-headed hellhound that guarded the gates of Hades in Greek mythology that prevented any of the dead from leaving once they crossed over the river Styx. So I thought that was a good analogy for the three laws that we're going to be kind of walking through today. The laws that we have to deal with are the what's now called the ADAAA. It's the Americans with Disabilities Amendments Act. So it was amended in 2009. So it's now got a couple more A's after it. Workers' comp we're all familiar with, and the third head of the beast is FMLA. So what I want to do, as Joanne mentioned, is just kind of walk through an overview of the three different laws. I won't spend a lot of time on workers' comp. I think everyone here deals with that probably more than they want to. But basically, workers' comp is designed to help injured workers recover from their work-related injuries, to provide them with medical treatment that ensues as a result of the injury, and also provide them with an amount of time to recover from those work-related injuries. The Americans with Disabilities Amendments Act is much broader in coverage, and the Amendments Act has really, from the defense side, we just say, it's basically everybody gets to play at this point, because the Amendments Act has significantly broadened the coverage of the ADA. The ADA applies to all employers with 15 or more employees, and state and local governmental entities. The feds are under a different system, but the same laws basically apply. And basically it makes it illegal to discriminate based on disabilities from the application process to the termination process. So it covers the complete spectrum of employment-related issues. Now, before the Amendments Act, courts had interpreted the act very narrowly. So you had to have not only a disability, but you had to have this disability that impacted a major life activity. So a lot of times the fight was whether or not the person's alleged disability prevented them from doing some of the basic functions of life, like being able to take care of themselves, being able to cook, clean, all those things that we do as kind of major parts of our daily living. What the Amendments Act did was it was significantly broaden the coverage, and basically what it said was that although the words are the same, it has a much broader coverage. And one important difference is under prior case law, you had to take into consideration mitigating factors. So for instance, if you were a diabetic, but you could take insulin and manage your disease, and you were able to function on a kind of baseline level. Now what the Amendments Act says is you don't consider what the impact of the mitigating factors is. You consider it based on what the disease would, how it would affect you without the mitigation. So now the coverage of the Americans with Disability Act has expanded tremendously because of that interpretation. And they've also implemented kind of general guidelines and basically per se conditions that would be considered disabilities. So for instance, cancer, anything that affects the immune system, for instance, HIV, anything that would affect brain function. So basically, you name it, it's probably covered under the Disabilities Act. Now, there are three ways to kind of get coverage under the Disabilities Act. One is you have an actual disability. Two, you've got a record of a disability. That is, you may have had some disability in the past. Now you're apparently recovered, but there's this history of a disability. And the third prong is regarded as disability. And under the Amendments Act, this is the preferred method to get coverage. And under the regarded as prong, you can't have a disability, you can't have a disability, it doesn't really matter. It's that you were considered to have a disability. So, for instance, Joe, who we'll talk about later, comes back from a workers' comp injury. His back condition has now, recovered, but the employer is still a little worried about Joe's ability to lift. So he treats Joe differently than he does other employees because Joe is regarded as having a disability.
So even if they aren't disabled, they're not representing them as disabled. If you, the employer, perceive them as disabled, then they're going to get coverage. Because and that's the scariest part for these employers, because nobody wants to bring back an injured employee. They don't want to they want to get rid of them, they want to move them out. But you bring them back, if you treat them differently, even if he's not disabled, the court will say, well, you perceived him as disabled and the act's going to apply.
And the other impact of that, or aspect of that, is the record of. So if someone has a work-related injury and comes back to work, even if they're completely healed, they still have this record of disability. So based on that, they would probably get coverage under the ADAAA. And what the ADAAA basically prohibits is discrimination in employment based on the disability. So in other words, someone who is otherwise qualified to do the position can't be treated or discriminated differently. And it's important that keep in mind they have to be able to do the job with or without an accommodation. So if someone before any alleged injury or disability couldn't do a particular job, let's say for instance me in accounting, there's no way it's going to happen. Okay, I can't now claim that because I have some alleged disability that you have to give me an accounting position, because no matter what kind of accommodation you provided me, I'm not going to be able to keep all the books straight. And I couldn't do it before, can't do it afterwards. So it has to be someone who's otherwise qualified to do the job. Now the impact of the ADAAA is basically, the original estimate was that it was going to increase coverage by about 12 million workers. Now that estimate is near 40 million additional workers will be covered under the ADAAA. So the bottom line is, if there's any suspicion that someone's going to be covered under the ADAAA, more than likely they are going to be covered. And the defense of these cases is now, the kind of the line of scrimmage has shifted. Before the Amendments Act, we were fighting over whether somebody is disabled, whether or not it impacted a major life activity, whether or not it was a serious condition. Now that's basically assumed. Now the fight is going to be whether or not we provided a reasonable accommodation, or whether or not there's proximate cause between, that is a cause and effect relationship between the disability and whatever action we took with them with respect to their work. The discipline that we provided, or their termination, whether or not they can prove it was tied to discrimination based on their disability. The Family Medical Leave Act.
Are there any questions on the ADA?
This is the third head of the dog, and basically here we have coverage for private employers with 50 or more employees at a work site within a 75-mile radius, along with public and elementary and secondary schools, as you see there. And the FMLA coverage is in some ways broader than workers' comp. In some ways it's a little narrower. Our workers' comp will cover any employee no matter how long they've been working for us. The FMLA requires a certain amount of not only time that they've worked, but also in terms of duration, but also in terms of hours actually worked. So they have to work for the company for 12 months. And it doesn't necessarily have to be consecutive, but they have to work for us for 12 months. And they have to work 1,250 hours within the 12 months prior to coverage. So it's a little narrower in terms of its focus in terms of coverage. But it's broader because it covers not only work-related injuries, but any serious medical condition, not only for a serious medical condition of the employee, but any family member. And the recent amendments have included service member coverage. So if an employee has a qualified service member who's either called to duty and they have to take time off to help care for their children, or if the service member is injured while on duty, they can take time off to help the service member. But I want to focus on just basically kind of the injury of the employee in terms of coverage of the FMLA. And basically what the FMLA does is give employees a right to take 12 weeks of unpaid leave. And it doesn't have to be in a block. It can be intermittent leave. It can be you know, a couple hours to go to a doctor's appointment, or it can be for the entire 12-week period. And as I mentioned, it can be for their own serious health condition or a family member. And the serious health condition under the FMLA is defined a little more narrowly than what maybe a workers' compensation injury would be defined as. It has to result in an overnight stay in a hospital or a period of ongoing treatment. And liability out of the FMLA comes from either retaliation. They allege that the employer took some action against them because they took leave. So if someone's just off of FMLA leave and they're fired, more than likely the employer is going to probably get a retaliation claim just because of the timing of it. And there's also an interference claim that can come out of FMLA where the employee claims that the employer interfered with my ability to take FMLA leave. They didn't give me the right form, they didn't let me take the time off I requested, they claimed that my serious health condition wasn't justified. So those are the two claims that we see coming out of FMLA. So I think there's an argument in terms of what's broader or narrower, workers' comp or FMLA, but I think the important point is the ADA is kind of the umbrella that will cover a lot more of these issues than what either FMLA or workers' comp would cover. So as we talk through today, we're going to try to keep in mind that impact that the ADAAA will have over all of the issues that we may discuss. And I think one of the biggest issues, as Joanne pointed out, is this whole issue around leave. And you know, as you know, with workers' comp, you're off for a period of time until you recover from your injury, and then you're expected to return back to your position. Now, under the FMLA, you're also entitled to 12 weeks of time off, unpaid time off, to you know, care for your serious health condition. Now, the real rub comes, I think, with the ADAAA, that we have to provide a reasonable accommodation, and that reasonable accommodation can come in any number of forms. It can come in the form of changing some of the non-essential functions of a person's job. If you know their job is a administrative assistant, and on occasion they have to carry a box of paper to their desk to load up the copier, that's more than likely not an essential function of their job. So if they have a back injury, you can require somebody else or ask somebody else to do that for them. So you have a job modification as an accommodation. But the other issue that comes up more and more is this issue of leave as an accommodation. Whether or not someone taking some additional time off, despite whatever policy the employer may have, whether that would constitute a reasonable accommodation. And the trick is that there's no one-size-fits-all answer to this issue of whether or not leave constitutes a reasonable accommodation. You have to have what's called the interactive process. And that's basically a dialogue with the employee in terms of what can we do to help you do your job in light of your disability. And
sorry, but with the FMLA, what you guys need to make sure that your contacts are aware of is if there are 50 or more, most of your, the FMLA is going to apply. They need to make sure they're running FMLA consecutively or contemporaneously with the TT. So if an employee goes off on TT, send them their FMLA notice. Start that 12-week ticking. Most employers know to do that, but sometimes whoever's coordinating workers' comp and benefits isn't talking. So if you have someone off on TT and ask them, are you covered under the FMLA? If so, make sure they're running the FMLA notice, because you don't want to have be in the position of somebody coming back after 16 weeks of being on TT and they still have 12 weeks to burn under the FMLA. And it's not that my goal is to terminate these people, but you don't want to give them any extra time, because you can't discriminate or retaliate, but you can discipline employees as you would any other employee. So just because they've used FMLA or they may have FMLA doesn't mean you cannot treat them as you would any other employee and continue to counsel or discipline them. So just make sure if they're on TT, you start the FMLA clock ticking and you start that running.
yeah, and so as Joanne points out, you've got this kind of continuum of leave. So under workers' comp, the individual may be offered TT for 6 weeks. Then if that clock's not ticking, if they're not burning up their FMLA leave while they're out on workers' comp, they can say, even though their doctor releases them return to work, they can say that, well, I've still got this serious medical condition, and then get another 12 weeks after that. And then this whole issue of whether or not leave is an accommodation may extend that leave even further, even if the employer has a written neutral leave policy. What's important is that indefinite leave is not considered to be a reasonable accommodation. So if their doctor says, I have no idea when this person, if ever, is going to be able to return to work, then you don't have to just let them float out there. You can go ahead and proceed to take action against them, because it's not reasonable to extend leave out indefinitely.
You may want to check with your employers to say, do you have a leave policy? I know we're working with Michelle with a client that doesn't have a leave policy, which is unusual. Some people just say, well, I give them their 12 weeks. Once 12 weeks are up, if they can't return, I cut them loose. Well, you can't do that under the ADA, no automatic. And 12 weeks is going to be considered by the courts as too short. Some employers say I have a 6-month leave, or people are hanging out there, or I have a year. But even at the end of that policy, you still have to do this ADA interactive process. But you're going to want to know what their policy is. They should probably, most employers should have some policy, some written policy, whether it's, we'll look at it after the end of your 12 weeks, but anybody who's covered by the FMLA has to give them 12 weeks.
Yeah, I think that's important. I think a leave policy is always helpful, but it can't be this one-size-fits-all situation where an employer just simply reacts based on what's on the paper, no matter what the underlying facts are. And based on the expansive interpretation of the ADAAA, I would say 99 out of 100 workers' comp claimants are going to be considered to be disabled under the ADAAA. So I think it's going to be an automatic issue that the employer's got to be aware of in terms of actions that they take with people who've had workers' compensation injuries. And again, it's not even that they're actually disabled. If they're regarded as disabled or have a record of this disability, i.e. they used to have a comp claim and now they've got this record of disability, they can still be covered under the ADAAA. So I think there's an automatic trigger that should go off whenever somebody has a workers' compensation claimant that they're dealing with in terms of termination or other disciplinary issues. Another intersection that we see often is in terms of treatment of medical records. And just quickly, under the workers' comp system, we've got a pretty broad range in terms of what we can request in terms of medical records. Under the FMLA and ADA, that's much more limited. Under the FMLA, to be safest, there are forms that the government has that should be issued that can answer or ask specific questions in terms of whether or not this person has a serious medical condition. And under the ADA, it's limited to, okay, does this person have a disability, and if so, what, if any, accommodation can we make to allow them to do their job? You can't just probe completely into their medical backgrounds if it's outside of the scope of what's going to be necessary to determine how it impacts their job. Light duty is another area. Obviously, in the workers' comp context, if you've got a light duty position available, you offer it up to the individuals out on TT. It's within the restriction. If they refuse it, we can cut them off with TT. But under the FMLA, even if you offer them a light duty position, they can still take their 12 weeks. And if you bring them back on light duty, it doesn't burn up their FMLA leave. So they're not out on FMLA if they're in doing a light duty job. And under the ADAAA, a light duty position can be a reasonable accommodation, but you don't have to create a new position for the employee with a disability. So you don't have to change the essential functions of a job to create a light duty position for it. But if there's an existing position that's vacant, that could be considered to be an accommodation.
So say you fail to give somebody FMLA notice, they go out, you make them a light duty offer, they refuse. A lot of employers want to terminate. Your TT might be cut off, but you can't fire them because you haven't given them that. You're taking a big risk if you terminate them because you haven't given them the 12 weeks. So not that we expect you guys to talk them through this, but issue spot and say, did you give? If you didn't, you need to talk to someone in employment counsel before you terminate because there's FMLA leave still out there. It should, depending on how a hearing officer interprets it, it should stop the TT, but it may not allow you to terminate employment.
The other issue is in terms of return to work certification. Again, under the workers' comp scenario, we ask for release from their doctor that they're able to perform their job and that they're not under any restrictions any longer. Under the FMLA, as long as you tell them up front that you're going to require them to have an examination before they come back to work, and you treat everybody the same, then you can still require them to have a return to work examination. And under the ADA, it's a little more limited. Again, it has to be a discussion based primarily on what, if any, accommodation can we implement that allows you to do your job.
I don't know if you guys run into this. We see it with transitional work programs. Some people don't have a limit on those. Some people have 90 days, some say 180. If you haven't returned to your former position, then you go back off on TT. Some people say you need to submit certification like a Medco 14 every 30 days, and we need to see a progression or improvement in your restrictions. And then they have that weasel language that says we can extend it, based on individual fact situations. The problem is if you have an open-ended transitional work policy, let's say we have people doing light duty, they don't have to be out in the freezer, at the warehouse, they're in the office watching TV, whatever. They don't want to go back to their former position of employment. If you leave them in that light duty job for too long, then you may have created a permanent position for them. The purpose of transitional work is to transition them back to full duty. Once you've created a job and then you get permanent restrictions on them and the doc says they can't go back to their former position, it's hard for us under the ADA to say you can't accommodate that position because you've been accommodating that restriction for 2 years. So you got to be careful and make sure the employer doesn't get into the position of having inadvertently created a position when they shouldn't have. So sometimes having a limit with the appropriate weasel language on those transitional work policies is important. When it's too open-ended, then you may, because we're not required under the ADA to create a position. It has to be an open existing position that they qualify for. So they may have burned themselves by leaving somebody in light duty too long.
And so basically where we see the exposure in all three of these acts is all three of the acts have some provision that prohibits retaliation. So if the employer takes some disciplinary step up to and including termination, and they can establish that there was a tie to either them filing a workers' comp claim, the alleged disability, or them taking FMLA, they can bring a retaliation claim. And frankly, the retaliation claims are sometimes the most dangerous kind of claims to litigate, because even if you can dispense with the underlying allegation with respect to discrimination, they can still bring the retaliation claim. So, for example, I filed a claim for discrimination. Court finds that there's no discrimination, that we took whatever action we took for some legitimate reason. But they still have an argument that you took that action because I filed the claim, regardless of the legitimacy of the claim. So sometimes you're still fighting on the retaliation, even if you can dispense with the underlying discrimination claim. Obviously, you've got discrimination based on either the disability taking leave issues. Interference comes into play with respect to really all three of these statutes. If you're not accommodating someone with a disability, or you're interfering with someone's ability to take advantage of the workers' compensation system, but more specifically with respect to the FMLA, if you're not allowing people to take the leave that they would otherwise be entitled to. And obviously, you've got to comply with all the requirements of each law. If someone's out on workers' compensation, they've got to legitimately awarded injury and medical treatment that's been approved by the Industrial Commission. You've got to obviously pay for that treatment going forward. And the same in terms of FMLA. You've got to have the appropriate notices up, and you've got to treat the or allow the employees to return to their former position at the end of that leave period. And then obviously the liability that can grow from any of those allegations is really what we deal with at the end of it. Any questions so far? Okay, let's talk about Joe. And this is just a hypothetical that we can hopefully talk about some of the issues that we've discussed. So Joe's a factory worker. He works on the line. One day he has a pretty serious back injury that requires him to be out of work, and he ends up having to undergo surgery. His doctor says it's going to be about 8 weeks before he can return to work. And
that's conservative.
Yes.
8 weeks.
it works in the hypo.
He meant 18 months.
So at the end of that 8-week period, it ends up that, you know, Joe's prognosis is pretty bad. He's got a permanent injury and he's going to have permanent restrictions. So I guess if we look at it just in terms of individual silos, we can talk about workers' compensation first. So what happens at the end of the 8 weeks under the workers' compensation scenario?
Anybody want to answer?
And let's assume the doctor said, you know, in terms of the prognosis, again, this is a permanent injury. This is as good as it's going to get.
So he's MMI after 8 weeks.
You're giving the answer. I mean, you don't get free donuts. Okay. So yeah, I mean, he's MMI at the end of the 8 weeks at the end of the 8-week period. So his temporary total disability can be cut off. And is there any requirement that we bring it again? Just focusing on workers' comp. Any requirement that we now bring him back to some other position at his former plant?
No.
Right. I mean, so under again focusing solely on workers' comp with our blinders on, we can fire the guy. He can't do the job, so we can let him go. Well, now we've got to bring in these other laws that we've talked about. So FMLA, he's been out 8 weeks. This is where the 8 weeks comes in. So he's been out 8 weeks. What does he get under FMLA? Well, so he gets an additional 4 weeks. So we can't fire him yet because he's got 4 weeks of FMLA leave that he can still take. And so at the end of that 12 weeks, he still has this permanent injury. He can't do his former position, at least as it was designed initially. Can we fire him again under FMLA? Can we fire him now at the end of the 12 weeks? Answer is probably yes, with one restriction. If you fire him on the 13th week, what's he going to do? Exactly, he's going to bring a retaliation claim because of the what the courts call temporal proximity. That, you know, it's so close in time that you can argue that it's probably a result of his FMLA. Now let's bring in the biggest head of this three-dog monster, the AD AAA. What, if anything, can we do at the end of that 12-week period under the AD AAA? Can we fire him? Probably not. Probably not. What we have to do is engage in what Joanne initially talked about, this interactive process. We have to talk to Joe to see if there's anything that we can do for Joe that's going to be able to help him do his former job. You know, is there anything that we can, any non-essential function of his job that we can take away to allow him to continue to do that job with his permanent restrictions? Or do we have an existing light-duty job that we can give him that would allow him to stay employed? Again, we don't have to create one, but if there's one available, we may be able to give him one. And then also, is there, you know, arguably an additional finite period of time that we can give him additional leave that may help him recover? Probably not in this situation because his injuries, as we said, are permanent. But so you've got to go through that process, and the process has to be documented before you can actually let him go.
And when he says the process needs to be documented, on the employer side, they need to establish that they have looked for open light-duty jobs, existing ones that he might be able to do. And then they also have to document the interactive process with the employee by sending them a letter saying, hey, you know, we've got this, we have these permanent restrictions, you can't, your doctor says you can't do your former job. Is there any, you know, call us or contact us if we want to discuss if there's anything we can do to help you return to your former position. Then the onus is on the employee to come back and say, you know, no. And usually if an employee is on TT, they're not going to want to give that up by saying, yeah, I think I can come back and do my job. So hopefully it all works out. And we often walk clients through with almost like a script of how to do this. And we always say, have 2 people in the room, be on speakerphone, have a witness. But the rub comes in when, if they have a leave policy, they have to follow their leave policy. How have they treated similarly situated people in the past? So you need to look for, what have you done in the past? What's your history? Because you don't want to make a case of first impression. You don't want to treat the workers' comp claimant who just exhausted FMLA, you don't want to use him as the test case. So you got to look back at what have you done in the past. and then be consistent with that. So if they have a leave policy, you gotta follow the leave policy. And that's the hardest thing for employers to do, is if you have it in writing and you have the policy, you gotta follow it. That's why a lot of people avoid having policies, because they wanna be able to make up the rules as they go along. So that's the big thing, is just gut checking your employer. It's not your responsibility to walk them through this, but it is, I think you add value to your services by issue spotting for your clients. Again, it's not your ultimate responsibility, but they will appreciate it if you save them from, these lawsuits can cost $100 grand to defend employment lawsuits, because they are fact-based, they are case-by-case scenarios, and there's a lot, they're intensive on discovery, witness interviews, every supervisor, every person, the decision makers are interviewed, so they are extremely expensive. And if you can avoid that by just bringing up some issues for them, you've added a lot of value to your services.
And I think that's absolutely right. And the thing that I think makes a lot of employers' heads explode is that, you know, the EEOC and even if the case gets to court, emphasizes that there's not this one-size-fits-all issue. That you have to have kind of a tailored discussion with someone in terms of what accommodation you may be able to have. And all of that information that's being gathered in that process ultimately is going to be evidence that there's a lawsuit that's being brought. That's why it's so important to carefully document it. And what the courts want to see is they want to see a good faith involvement by both sides. So if the employer reaches out to the disabled worker and the disabled worker just gives them the back of their hand and says, you know, I'm not going to participate, then they haven't participated in good faith, and they're not going to be able to say, you know, they didn't accommodate me, because it's really up to the disabled worker to come up with the accommodation that's reasonable. And then the employer also has to engage in this process in good faith to really look for anything that they may be able to do to accommodate the employee. And the accommodation has to be reasonable. It can't cause an undue burden on the employer. So a lot of that's going to be determined based on the size of the employer, the type of job that's involved. You know, so if an employee says, well, I want a robot to assist me in doing my job. Well, you know, if you're a small operation, even a big operation, you probably can't give them a robot. But if there's some way you can, you know, change a part of their non-essential part of their job to make it a little easier for them, you may be able to do that. So you know, that interactive process is key, and you've got to be able to document it. And you know, they should keep in mind that this information is going to be used if it goes to litigation. This information, this documentation, is the evidence that's going to support the employer's claim. All right, so we've tamed this dog. So what questions do we have now about kind of the interaction, just things you guys are dealing with?
I have a question.
Yeah.
If that injury was a non-work related injury, that scenario, you know, most of the employers don't accommodate, don't provide light duty for non-work related injuries. So now, I've had the comment of, you know, we have 4 light duty jobs, we reserve them strictly only for work comp claims, but now they feel like they're open to have to fill those positions with non-work related injuries. Is that the case, or are they misunderstanding?
No, I mean, you have to be able to, you know, have this interactive process, but
Yeah.
again, for the AD AAA to apply, they've got to be able to do their job with or without an accommodation.
Okay.
So if this non-work related injury prevents them from doing their job, you don't have to give them another job.
Okay.
That's just the light duty position. That happens all the time, that people have these light duty jobs reserved for that reason, for people coming off of work injuries to be able to rehabilitate and transition back into work. But that, you know, that should be included in the discussion in terms of, you know, whether or not that's reasonable under the circumstances.
Well,
but it's not automatic.
And a lot of my employers have light duty jobs when they feel like it. You know what I mean?
Or they
So
like
there's
the employment.
Right. There's no formal transitional work plan in place. There's no, it's, oh, we could probably stick them everywhere. You know, the days of sticking them in the meat cooler to, you know, measure the temperature. I mean, it's very informal light duty programs. And then they also have this belief now that they have to accommodate everybody. I don't know what that's about, and I think it's just a non-education, but.
It's a balancing act between whether they want to have TT, whether they're SI that want to pay it, or have it charged against them. For some employers, you got to step back. They're gonna, and you may not be privy to this information. If this person's a thorn in their side and they just don't want them in the workplace,
right,
they'll pay the TT. If they really want to screw with the employee,
yeah,
they'll bring them back and have them paper
Right.
clips, that type of thing. But if they have something in writing, they need to apply it, because believe me, Joe Blow knows how
Yeah.
you treated Mary,
Yeah.
Tom, and whatever.
Yeah.
And that's the big problem. The other thing that we run into is, and it's in Michelle's case, where the doctor keeps extending the C-84 every month till the next visit. So is that a reasonable accommodation to extend that leave under the ADA one more month? So at some point, you gotta take the risk and cut them off. And that's where employment counsel and the employer have to be involved. It's when you get conflicting information where the clinic says, I can't do anything, or you know they're looking at another surgery, but the doctor's saying, I think they can do light duty. It's just completely inconsistent. And then you have to talk about, well, what are our options? They've exhausted leave, they've exhausted, they've exhausted all of our leave, FMLA. We need to look under the workers' comp, they're still on TT, we need to look at the workers' comp medical, and then we make that decision about, do we wanna set them adrift and then say, feel free to reapply when you're full duty.
I have a question. On the sales side of things, well, maybe Matrix can answer this. Should we be strongly recommending that transitional workplace program for just this fact that they need to have this light duty in place prior to an incident? I mean, it's a BWC program, but we don't administer it. But is that something we should strongly suggest to the clients?
Well, if they don't have one now, then they can use the BWC programs to
Right.
implement it and get that incentive. And if they don't have one, then they certainly should be putting it in place.
So you strongly recommend that for kind of protection and going forward?
Well, I don't know that it protects them, but it helps reduce their claims costs, which is what your guys' focus is on.
Okay.
Plus, it helps when they're trying to bring people back. The problem is they have to be consistent. And HR needs to be involved in, whoever's in HR doing benefits or workers' comp needs to be involved, and the supervisors probably need to be trained. And the BWC does do that. But that's the problem, is when you have the program, you gotta consistently apply it across the board.
Yeah, I mean,
I'm sorry.
these ad hoc policies and practices are so dangerous. I mean, I don't want to get too far into the weeds of litigation, but where you want to kill the case is at the what's called the summary judgment stage before it reaches a jury. Because obviously a jury is going to be, frankly, it's not going to be a bunch of employment defense lawyers. It's going to be a bunch of working folk who say, yeah, I got hurt on the job and they screwed me too. So what you want to do is try to end it before it gets to the jury. And to do that, you've got to be able to demonstrate that you treated this person, even though they aren't FMLA or had a workers' comp claim or had an alleged disability, you treated them the same as you treated everybody else. And so if you've got these ad hoc policies, what happens in discovery, and discovery is the stage in case for you guys who've been fortunate enough not to be involved in litigation, is when everybody gathers up all the documents, all the emails, all the notes, all the files that the company has, and somewhere in that bunch of stuff is going to be, Mary, the great employee who we want to make sure we took care of, and Joe, the slacker, is going to say, look what they did for Mary. And they didn't treat me the same as Mary, therefore it's discrimination. So they've got it helps protect them if they've got these policies in place, and not only they have them in place, but they follow them. So
In our communication with you guys, as Rich reminded me recently, is not privileged, because sometimes I'm a little loose in my communication. So if we need to vent or talk about what's really going on, pick up the phone, because we have an obligation during discovery to preserve all emails. Yours would be, anything between us would be turned over. Anything between us and the client would not necessarily be turned over. They'd have to prove that that's not privileged or confidential. There was another area that we're seeing a lot of, and I can't remember it now. So.
And that comes up all the time, because you're, sometimes there are workers that employers don't want to have come back, and they have this frank discussions with you and with us about that. And it's better to have those frank discussions over the phone or in person than to have them documented forever, because they may come back out and you're sitting in a deposition saying, so why do you think Joe was a slacker? Or, why do you say that never want to see Joe's face in this place again? So, you've got to just have to be careful when having those discussions, that they may turn out.
In follow up on that, I remembered, they can still discipline and apply their policies. So if you have a bad employee who's almost out the door on points, absentee points, whatever, and you think that they're probably filing this claim because they think they can be protected from being discharged, treat them as you would any other employee. Document, discipline, written notices, or you have the employer who feels bad because so-and-so, you know, exploded the fryer, and we don't, you know, he did something wrong, he's been told about it, but, you know, my God, he nearly died, we're not gonna document that. No, you gotta discipline him for that. So you can still treat them as you would any other employee. And there's case law out there that says if someone returns to work on light duty, they accept that position, they come back, but yet you discipline and they lose their job as a result of that, you know, they don't show up, they don't, you know, they're tardy, whatever. If they, it used to be that you can only voluntarily voluntarily abandon a former position, your full duty job. Now there's case law that says you can abandon a light duty job. So if you get moved out, if you violate a written work rule while you're on light duty, that can still bar TT.
And, you know, I was involved in a case several years ago. We kind of had the opposite, where they claimed we papered the file because we were trying to trump up charges on a particular person. So you got to be, again, you just have to be consistent. If somebody who's a bad employee files a claim, you can't, the employer should be very careful about all of a sudden papering his file with a lot of discipline issues where they didn't do it before. So it's, again, consistency is really what helps if the case, you know, ultimately ends up in court.
I have a question on light duty. I have an employer who's been accommodating restrictions for 2 years because they, well, they're state funds, so it takes 2 years for them to come on their experience. They're just now coming onto their experience, and now they're like, okay, we're tired of them being on light duty, and what can we do?
While they're on light duty, you need to make sure, and this is where you guys really can help, is following up with that physician of record and getting permanent restrictions or an MMI finding. Because then if you take them out of that light duty position, they're not going to be entitled to TT, or they might get wage off.
They are though. He's saying that he's not MMI.
It's a
no surgeries required. No, no surgeries required. So he's not an MMI. The restrictions will barely change, and then they'll go back and forth.
Well, they either have to put him off and let TT be an issue, and the Bureau do the extended disability in 90 days, or they have to bite the bullet and get the IME. But you can't have that issue addressed unless they're requesting or receiving TT. It won't be ripe for adjudication, as they say. So you got to make sure the timing's right on that, because
you can't do what?
You cannot have an MMI finding unless they've requested or are on TT. And that burns a lot of people because they don't want that on their experience. So they go get the IME and they file the motion to have an MMI, and the hearing officer says, I don't have jurisdiction to hear this.
Okay.
So it's a timing issue, and a lot of times it might be worth it to pay the $500, $600, $700 for the IME than to wait the 90 days, have 90 days of potential TT.
But they would have to stop accommodating first.
Yeah.
Right. And when you have 2 years, how do you say I don't have a position for you?
Well, and I tried, they were like, what about settlement? I tried sending him a letter for settlement, and he said, no, I'm good. I like it.
And you do run the risk, if you can get the permanent restrictions, then maybe you can put them in voc rehab, get them to another employer or something else.
I know, I feel like I've exhausted everything, because we did that same exact thing. He doesn't want to do voc.
Who's the chiropractor? I'm assuming it's chiropractor.
I don't think it is a chiropractor. I don't know.
And we've had a whole rash of those in SI, and we've done the same thing. The employer does not have to accommodate them. I mean, if you put them on TT,
well, there's
they're
for
fine.
TT hitting and then getting that reserve, and
yeah, but
just
it's
not
only
coming on their
it's only a
experience.
short period of time. You get that exam scheduled, you put them on TT. Sorry, we're not accommodating. You're going to get TT. When you get the report, you file the motion, and you're in hearing. You know,
and you may get lucky if it's been 2 years and the hearing officer says,
yeah,
these are permanent. You know, if they see it, depending on the hearing officer, you could get lucky.
Okay.
and then who cares if they don't want to vote rehab? Then they can
Once you
file
get
a
that
wage loss.
MMI, I mean, seriously, unless they have some newer change, substantial change in circumstances,
Yeah.
they're not going to get TT again. So you
That's it.
always want to make sure you
Right.
get the MMI either from a hearing or from the POR. Now, usually when the POR gives you MMI, they change docs.
Right.
So to Murdoch.
Yeah.
That's who it is. I'm just kidding.
He's going to have an unexplained accident one of these days.
But
There I go with my loose lips again.
But doesn't
I can edit that out.
Doesn't that MMI up when they change doctors? If they're POR?
It should, but, it
But yeah,
just
they'll turn
depends.
around and file for TT.
Yeah, they'll still try it.
Mhm.
Yeah.
Any other questions?
Any other scenarios that you guys are running into, issues you're having?
I have one. I have an injured worker had surgery. This is a claim from 2008, 2007. She was working with light duty restrictions. She was off for years, and then we finally got her back light duty. They released her light duty. Employer was able to accommodate, brought her back modified duty. While she was working light duty, they put permanent restrictions into place. We got a FCE, put permanent restrictions into place. The employer was trying to decide and do that interactive process with her, trying to determine if they had something. They have put forth a great effort in doing that. However, it's taken a month or two. Meanwhile, she's working under those permanent restrictions. Is that going to be an issue?
Because now they've kind of accommodated her permanent restrictions in a transitional or light duty.
Yeah.
So I don't think that's gonna bar them. I think, I would argue, spin it as that's good faith. If they're trying to confirm, whether she can do her former position with a reasonable
The
accommodation.
only concern I would have is this undue burden argument. If they're able to, accommodate her in this position now, are you saying that they don't want to continue to do it in the future?
It's not a permanent type of position. They were accommodating her in a modified duty temporary position, and then the doctor decided to stay with those same restrictions and make them permanent. But in the process, she was continuing to work, and while they were making the good faith effort of trying to find work, because she is very skilled in other areas, so they were trying to determine if they could put her in a desk job or be an TNA type position, what they can do. She's since now worked a month in what's
with this permanent
technically a permanent position, even though they have not addressed that in writing to her.
I think the only concern I would have is that the employer would need to be able to ultimately demonstrate why it's an undue burden to keep her in that position. And they may be able to do it by saying, we hold those positions open for people transitioning from work-related injuries, or we just can't, we need to permanently fill that position. But at the end of the day, it sounds like she's not able to do her former position with or without an accommodation.
Is she an STNA?
Yes, she's an STNA.
And now they're trying, I don't think you're gonna have that much, unless she's been going for additional degrees or,
She
rarely.
has.
Okay.
Yeah, she has. She's actually finishing up school in accounting. So they have, they thought maybe they could use her in another department. They have multiple facilities throughout Ohio, so they thought, well, maybe we'll contact all these facilities to see if there's something else. Maybe we can move her, maybe we can work something out here. So it's been an ongoing process.
Self-insured?
They are self-insured. Mm-hmm.
And keep in mind that permanency is not equivalent to MMI.
Also, she has a separate claim for a knee injury that was in litigation, and we finally determined we didn't want to bring her back if that claim was allowed, and they allowed her to continue to start trading again. She brought that one back up, and since then it's it's not been allowed. There's been no further treatment allowed. She's MMI, she's done. So they also wanted to consider that as part of it as well.
Well, do you really have to look at what other skills, transferable vocational skills she has? Or is it, the focus is, can you perform your former position of employment with reasonable accommodation?
Yeah, with or without an accommodation. So if the restrictions prevent her from doing her former job, and, there's no, temporary position that you can put her in that's going to change that because they're permanent, I think as long as you document that you had that discussion, and if her reasonable accommodations, I want this particular job, you don't necessarily have to make that accommodation. But it sounds like they've had that discussion where they've looked at the various options and they say, well, we can't do this, we can't do that, we can't do this. Then I think there's not a lot more that the employer can do as a quote unquote reasonable accommodation in that kind of circumstance.
They don't have to put her in a job that she may not have the qualifications for. Maybe she'll grow into it in 2 years, but as of right now, she's at the bare level.
So they don't necessarily have to find, even if they have transferable skills, they don't have to find other employment or hire them based on permanent restrictions that they can't perform their regular job.
The focus is the former position of employment.
Okay, the former position, okay.
Other question?
Kind of just something that I hear out in the field, I'm really new to Matrix, is that they talk about how they take care of maybe the employee who has 25 years plus, as opposed to the employee that's only been there 2 weeks. Are they lawfully allowed to do that?
You say take care of.
Well, more accommodating, more light duty, then they're more likely to let go of this person at 2 weeks than they are with the person at 25 or 30 year plus employment history with them. It's probably not my area of expertise. I'm just letting you know what I hear out there.
Sure.
I can't direct them either way, but.
I mean, I think that's dangerous, and I'm just kind of going through different scenarios, because usually the arguments in the reverse, the older employees treated differently, and they, have an age discrimination claim. But if you've got, again, it's kind of a version of the good worker, bad worker scenario. You've got to treat everybody the same. So if you've got a great worker, long-time employee, you treated them, a particular way. The short-term employee who's not as good has the same or similar circumstance, and you treat them differently, they're going to have an argument to make. And you can't say, well, this person was a better employee than that person. I mean, obviously, if there's discipline that's involved and that person violated some policy, you can discipline them based on that. But if the good employee, for example, if the good employee was late, you just kind of said, you stay late for me, don't worry about it.
Right.
The bad employee's late and you try to document it, you're going to run into issues with that.
Similarly situated people. We see it with investigations too, where supervisors are doing the accident investigation, longtime buddy, oh, I believe him, I trust him, rubber stamps the investigation, claim allowed. New employee, don't like, late a couple times. They are going to run them through every hoop, videotaping, reconstruction. If you do it, if you have an investigation protocol, train your supervisors, because that's where we see nobody's watching these supervisors, and they're subject to the emotion and the friendships, and we see rubber stamp for Joe, and poor Mary gets screwed every time. So just point these things out, that when they do training, they really have to emphasize, because the supervisors are your insulation. They've got to be doing things consistently, and when you bring supervisors up through the ranks, there's going to have that pressure, that peer pressure. Sometimes they move them out to other facilities, sometimes they bring them in from some other places, so you see a lot of pressure on those supervisors if they're making those initial claim determinations or validity determinations. Have we bored everybody to death? No? Very interesting, really. Really, you're having a good day, aren't you? She's had a lot of coffee. Very interesting.
So we're ready for part 2 then.
Yeah. Okay. Well, that's it. I think I sent over some information. Rich is much better, but if you have, Stephanie has access to my materials. The one's a termination checklist. One was just like a brief interaction of the laws. You can look at those or have them. Don't reproduce them to your clients, but if you have a question, call us first. I don't mind talking to any of you guys and just running you through questions or things to point out to your clients. Hopefully it comes back in goodwill, but if we can prevent, we're busy enough as it is, we don't need other lawsuits for. So. And our contact information, Stephanie has it.
Yeah.
Okay. Thank you guys for having us.
Thank you.